Okay. Hello, everybody. Happy Monday. My name is Alisha DeBerry, and I wanted to come on really quick. I am in my office today, and I'm doing some uh, content for my students, and I thought it would be live. I thought it'd be great to come live to actually share it with you as well as I share it with them. Okay. So, what I am going to be talking about today is the different types of property ownership specific, guys, listen to me, specific to North Carolina. And I'm going to jump right in, okay, and share the different types of ownership. The first is that of severalty. Okay, so when we talk about ownership and severalty, this means sole ownership. Sole ownership can be an individual person or it can be a single business entity. They own it in severalty as one by themselves. There is no one else there. The example that I give all the time is think about having a pizza, right? And if you own that pizza in severalty, that means that you own the entire pizza by yourself, right? You get to enjoy it. There are no other owners, right? So that's severalty. What's very different from ownership and severalty is what we call concurrent ownership. And concurrent ownership is that of joint ownership. Now, there are two types of joint or concurrent ownership that I want to talk to you about. If you have something to write with, I would just put as a general heading concurrent ownership and joint ownership. The two types of ownership under joint ownership is that of tenancy in common and joint tenancy. Okay. So the two that are under concurrent ownership or joint ownership would be that of tenancy in common and joint tenancy. Okay, let's talk about tenancy in common first. With tenancy in common, each owner has what we call an undivided fractional interest. It may be unequal interest. So think about that pizza, okay? And every owner, right? It's more than one. They have an undivided fractional interest. It may be unequal. So, whereas everyone has a slice of the pizza, their sizes might not be the same. Okay. With tenancy in common, they also what they have called unity of possession. Okay. So, together, they all get to possess the property. Okay. And then we'll look at co-owners may dispose of their individual interests without permission of the co-tenants. What does that mean, Alicia? That means that, guys, you have to excuse me, I probably need some water. So when we talk about co-owners can dispose of their individual interests without permission of co-tenants, this means that if we have the pizza, and I want to get rid. I'm owning the pizza with Sue, and I want to get rid of my slice of pizza. I don't need Sue's permission to dispose of my slice of pizza or my slices of pizzas. Okay. Now, what happens with tenancy in common is that whenever there's death, the undivided interest of the co-owners pass to their heirs. So with tenancy in common, there is no rights of survivorship. My slice of the pizza would pass down to my heirs. Sue's slice of the pizza would pass down to her heirs with tenancy in common. And this is the first type of joint ownership that we're looking at. The second would be that of joint tenancy. Okay. I think I misspoke earlier, so let me just make sure I'm clear. When we talk about concurrent ownership, the first is tenancy in common, right? And that has no rights of survivorship. And my slice of the pizza would pass down to my children, okay? When we look at joint tenancy, that's the second form of concurrent ownership or joint ownership. Now, though it's used in North Carolina, joint tenancy is widely used in many other states and is tested on the national exam section. Okay. The title must intentionally create a joint tenancy, and it requires what we call 4 unities or 4 elements in order for it to rise to the level of joint tenancy. And that is the unity of possession, the unity of interest, the unity of time, and the unity of title. We refer to this as PIT, the unity of PIT. Okay, so that means together they possess the property. Together they all have interest, and at the same time they are all taking title to the property. In North Carolina, for joint tenancy, the percentage of ownership interest can be unequal if it is stated in the title. Now, if the joint tenancy, listen to me very closely, has a right of survivorship, then that means that the joint tenancy is not going to be passed down to their heirs. The remaining survivors actually get to take title, right? So it's automatically, the right of survivorship is automatic in states other than North Carolina. But when we look in North Carolina as it relates to rights of survivorship, survivorship is not automatically. Okay, so the attorney must draft the exact wording in title required for right of survivorship. So again, when we look at joint tenancy, this is where it can get tricky. On a national level, it's automatic. You know, it comes with that right of survivorship. But in North Carolina, the right of survivorship with joint tenancy has to be requested, and you have to get your attorney to draft that specific language on the deed. Okay. Now, the next type of ownership that we're going to look at is tenancy by the entirety. This is only available to legally, and legally is the key word, married couples in North Carolina. It is the default ownership for buyers married at the time of purchase, right? I always tell people in North Carolina, it only takes 1 to buy and 2 to sell. Other types of ownership do not automatically convert to tenancy by the entirety if property owners marry later. So if someone purchased property outside of their marriage and then they purchased property prior to being married and then they got married, it's not going to automatically convert to tenancy by the entirety, right? They would have to go through a special process and get an attorney involved to help them with converting that type of ownership to tenancy by the entirety, if that's what they want to do. Now, also with tenancy by the entirety, there is an equal undivided interest, and it also has the unity of possession, the unity of interest, the unity of time, and the unity of title, as we saw with joint tenancy. Okay. And with tenancy by the entirety, it does have an automatic right of survivorship, right? So that means that two husband and wife married, one of the spouses pass away, then that remaining survivor spouse is going to inherit the property as a sole owner, okay? And also with tenancy by the entirety, that right of survivorship does override a will, okay? And in order for a married couple or a couple that purchases property together as being legally married to convey title to someone else if they wanted to sell it, that means that it requires the signatures of both spouses, okay? Now, so that was a lot. We started out talking about ownership and severalty. We looked at the concurrent ownership or the joint ownership, which is that by tenancy in common, joint tenants, with the rights of survivorship. That's not automatic in North Carolina. And then we looked at tenancy by the entirety. Let's go to what we call the hybrid ownership. And I'm going to slow down because I'm feeling like I'm talking a lot, okay? The hybrid ownership, okay? When we look at the hybrid ownership, that's that like condominium ownership, townhouses. And hybrid means, right, it's a combination of a couple of different things. It's a hybrid, it's a blend. As it relates to hybrid ownership, the general concepts that you want to know is that it is managed by the owners association. So for example, the homeowners association or the property owners association with the hybrid ownership. It is managed by the associations, okay? And it's governed by covenants and laws, okay? With hybrid ownership, it can be residential, it can be commercial, and or it can be mixed use or industrial, okay? So it can fall into any of those categories, but let's focus in first on what we call condominium. Some of you may have even live or currently live in what we call a condo. This is what we're talking about. And again, the condo is a type of hybrid ownership, okay? So the condo is governed by the Horizontal Property Act, such as the North Carolina Condo Act of 1986. So there is, you remember I told you that the general concept for those hybrid types of ownership would be that of it's governed by covenants or general statutes, right? So the general statute that actually governs condos is what we call the North Carolina Condominium Act of 1986. 1986 wasn't that long ago, okay? And when we look at the things that are covered in the state statute that is specific to condos, it talks about things such as the application, the developer's disclosure requirements. Also, the North Carolina Condo Act talks about the public offering statement and the fact that buyers have a 7-day rescission period on new condos. And if it's a resale certificate for resale condos, there is no right of rescission, right? So if it's a resale, there is no right of rescission. When we talk about new condo sales, the buyer has a 7-day rescission period, and this is covered by the North Carolina Condo Act of 1986, okay? So that's it for a condo, right? Easy peasy. We all know what a condo is, okay? Let's move on to townhouses or townhouse, okay? And that's another type of hybrid ownership, okay? Now with the townhouse, it includes ownership of at least the land upon which the unit sits, and it's usually attached by party walls. The individual unit owners have use of the common elements. So when we look at the common elements, that's going to be if there's a shared lobby or parking or a pool, right? With the common elements, it's owned by the HOA, okay? And the maintenance for those common areas would be funded by assessments and any periodic fees charged to the unit owners. Why? Because they get the benefit from it. So it's going to be managed by the HOA, but the maintenance is going to be funded by assessments that they may charge to unit owners. And there is a law also specific to townhouses, and it is the North Carolina Plan Community Act, and that's covered in the Junior Statute under 47F. Okay, let's move on to what we call cooperative ownership. Title to the land and building with a cooperative ownership is held by a corporation. All right. So what the tenants actually purchase are corporate stock shares. And here's the thing that you want to keep in mind with the cooperative ownership is that the tenants don't own real property, they own personal property. All right. And they have a proprietary lease and no individual deed for the unit. So all of this is a type of ownership for property. It's personal property because they don't have title to the land or the building. That's going to be held by the corporation. Okay. This form of ownership has not enjoyed much popularity in North Carolina today. And you can probably see why, right? Because it's personal property. And that's the distinction you want to make with the cooperative ownership, in that it's extremely different from the other types of ownership where the property owners actually own real property with the others. Okay. And then we'll move on to timeshare ownerships. Okay. So I know everybody's probably familiar with timeshares. It's also called a vacation list, a lease, vacation bond. You can have a club membership, prepaid hotel reservation, all of that. Okay. And what it allows is multiple parties to buy interest in the same real estate, hotel property, resort. Interest may be leasehold or deeded ownership, and the buyers receive right to occupy the property for a specific time period during their ownership. And it must be at least 5 separate times over at least 5 years in North Carolina. And guess what? You guessed it. There is a law that also governs North Carolina timeshares. And it's just what I said, North Carolina Timeshare Act. And then, the last type of ownership is that of a trust. And with a trust, there is some type of fiduciary arrangement. You have a third party trustee. They're going to hold assets on behalf of a beneficiary. And the trust agreement sets the parameters of the trustee's authority. And they can allow assets to pass outside of probate, which is why a lot of people like the trust, so that those assets don't have to go through the probate process. Okay. Now, brokers or in North Carolina should deal with trustee versus beneficiary regarding disposition of real estate. And that's very important. So guys, in a nutshell, I just wanted to cover the different types of property ownership in North Carolina, just a high level overview. Didn't get into a lot of detail, although I feel like I've been talking for a very long time. Okay. If you have any more specific questions, just general questions, I can answer those for you. But taking title to ownership or property ownership in North Carolina, that is legal advice. And you should consult an attorney to get specific guidance on how to take title to ownership, right? But if you're studying for your exam and need some guidance for that, I can help you. And so someone may say, well, Alisha, if we are not to give legal advice and we're not as brokers in North Carolina, why do we have to know this? You need to know how it operates. You need to have a general overview of how it works as a knowledgeable and competent broker in the state of North Carolina, so that you can just speak to it and then refer them to a licensed attorney for advice on how to take title to property in North Carolina. All right, guys, I am finished for now, and I'll chat with you the next time. All right, bye-bye.